Let's jump right into this explainer. Today, we're looking at how a single word, literally just one word, in a 1989 law sparked a landmark constitutional battle in South Africa over the very definition of family. The law we're talking about is the Judges' Remuneration and Conditions of Employment Act. And the 2002 case of Satchwell versus the President of the Republic of South Africa is this incredibly fascinating look at how the legal system wrestles with changing social realities. We're going to explore how one tiny legal term completely excluded a family from vital protections, and how the highest court in the land stepped in to surgically fix it. Here's our roadmap for today's explainer. We'll start with 1, the judge and the law, move on to 2, defining the modern family, explore 3, the constitutional equality test, discuss 4, the heterosexual cohabitation question, and finally, wrap up with 5, the court's remedy. All right, let's start with Section 1, the judge and the law, and the human cost of a legal omission. To really get this case, we have to start with the human facts. Because, long before this became some high-level constitutional debate, it was simply a story about 2 people trying to protect the life they built together. Judge Kathleen Satchwell and Leslie Louise Carnelli didn't just have some fleeting romance. They began their relationship way back in 1986. By 1990, they had jointly purchased a home. And in 1997, Judge Satchwell actually started writing letters to the Minister of Justice, trying for years to get the government to recognize their partnership and just amend the law. That effort culminated years later in the 2002 Constitutional Court judgment. Basically, they exhausted every single administrative avenue they could before finally taking it to court. And the sheer weight of the evidence they brought to the table was undeniable. They had overwhelming proof of deep emotional and financial interdependence. They had completed wills in each other's favor. They lived together in a jointly owned home that they considered their family residence. Carnelli was the sole beneficiary of Satchwell's insurance and investment policies, and she was even registered as a dependent on PARMED, which is the parliamentary medical aid scheme that judges subscribe to. They were completely intertwined, exactly like any married couple would be. But here is where the law created this massive, glaring gap. Under Sections 8 and 9 of the Judges' Remuneration and Conditions of Employment Act of 1989, there was a stark contrast. If a married judge died, their surviving spouse would automatically receive a lifetime payout equal to 2/3 of the judge's salary, plus a bunch of other gratuities. But if Judge Satchwell died, her partner of over a decade would receive absolutely nothing, 0. Moving on to Section 2, defining the modern family and the absolute power of the word spouse. The whole conflict blocking them from getting legal protection came down to the definition of one single word. In the context of that 1989 act, the word spouse meant a party to a marriage recognized as valid in law, full stop. And since same-sex marriage was not yet legal in South Africa at the time, this interpretation created an absolute, impassable barrier for Satchwell and Carnelli. The law effectively shut out any relationship that wasn't heterosexual marriage. I absolutely love this quote from the Constitutional Court because it perfectly captures their modern perspective on the whole situation. The court noted, "Families come in many shapes and sizes. The definition of the family also changes as social practices and traditions change. They explicitly acknowledge that the traditional form of marriage isn't the only valid family structure out there, and they actively warned against entrenching one specific type of family at the expense of all others." Which brings us to Section 3, the constitutional equality test and the Harkson v. Lane stages of inquiry. So, how does a court formally evaluate this kind of thing? To figure out if this exclusion violated the Constitution's equality clause, the court applied a rigorous 4-step checklist. Step 1, does the law differentiate between categories of people? Well, yes, it clearly differentiates between married couples and same-sex partners. Step 2, does that differentiation actually amount to discrimination? Yes, it's based directly on sexual orientation, which is a specifically listed ground in the South African Constitution. Step 3, is it unfair? Because it's on a listed ground, it's legally presumed to be unfair. And finally, Step 4, can this discrimination possibly be justified in an open and democratic society? Well, in a pretty revealing twist, the respondents, which were the President and the Minister of Justice, didn't even try to justify it. The government itself just conceded right out of the gate that denying these benefits to same-sex partners was unfair discrimination based on sexual orientation, and there was no way to justify it. They completely agreed that permanent same-sex life partners are entitled to build their relationships in a way that accords with their sexual orientation without facing this kind of unfair legal pushback. Let's head into Section 4, the heterosexual cohabitation question, and a crucial legal distinction. Now, despite conceding the unfairness, the government threw in a defense that complicated things. The minister basically argued, look, we don't want to fix the law piecemeal. He wanted to wait and just include all unmarried partners in one massive, sweeping legislative update later on. But this raised a really fascinating question for the court. Should same-sex partners really be lumped together with unmarried heterosexual couples? Do these two groups actually face the exact same legal hurdles? So the crucial point here is the sharp distinction the court drew. Unmarried heterosexual couples have made a choice to stay as cohabiting partners without marrying. There is absolutely no legal obstacle stopping them from going down to the courthouse and getting married to secure those benefits. Same-sex couples, on the other hand, were legally barred from entering a valid marriage entirely at the time. As a previous court ruling wisely pointed out, telling gays and lesbians they are free to marry someone of the opposite sex is just a meaningless abstraction. Because of that fundamental difference in choice, the court decided it was totally inappropriate to lump these groups together or make Judge Satchwell wait around for some hypothetical legislative overhaul. And that brings us to the climax of our explainer in Section 5, the court's remedy and surgical constitutional changes. So how do you fix a law that's found to be unconstitutional without just tearing up the whole statute and suddenly leaving all the currently married judges without any of their benefits? Instead of throwing out the entire Judges Remuneration Act, the court used a really precise constitutional tool called reading in. Reading in is this brilliant mechanism that allows a court to add specific, highly targeted words directly into an existing statute to cure its unconstitutionality, all while keeping the rest of the law perfectly intact. It's like constitutional surgery. But, and this is important, they didn't just grant a blank check to anyone who casually claimed to be a partner. The court noted that marriage inherently creates a physical, moral, and spiritual community, and that imposes very real reciprocal duties of support. Therefore, the Constitution can't force the state to take on financial obligations toward partners if those partners haven't actually undertaken those obligations toward each other. The court strictly required that the same-sex partners had to actively prove they'd undertaken these reciprocal duties of support, exactly like Satchwell and Carnelli had so clearly done with their shared home, their wills, and their intermingled finances. So how did this actually build into the final legal text? The court took the old phrase, surviving spouse of a judge, and surgically read in their new requirement. The law was instantly transformed to say spouse or partner in a permanent same-sex life partnership in which the partners have undertaken reciprocal duties of support. By injecting that incredibly nuanced phrasing straight into the statute, they cure the discrimination on the spot, without having to wait for Parliament to eventually get around to it. The Satchwell case is just a powerful testament to how rigid words in a statute can cause profound human exclusion, but also how carefully applied constitutional rights can remedy it. As you reflect on this landmark ruling, I want you to consider this. As our social practices continue to change, how will future laws continue to evolve to recognize the diverse, reciprocal duties of care that we choose to take on in our modern lives? It's a huge question, and it's one that courts all around the world are still grappling with right now. Thanks for joining me to explore this incredible case. Catch you in the next explainer.